Okay, we're going to get started now. I'm going to wear two hats. First is, along with Lisa, as co-chair of the program committee, a few announcements, and then we'll move into the last panel. So first, after this panel, the last panel of the afternoon, we'll take a 15-minute break, followed by the members' meeting in this room, after which we will have a closing reception, which will be immediately adjacent to this room. And I encourage everyone to stay for the members' meeting. We have a quorum requirement, and Sherry in particular wants to be sure that we have a quorum for the members' meeting. So rather than have to count doubles, I encourage everybody to stay for the reception as well. I also want to encourage everyone to attend tomorrow, either virtually or in person, for the Next Gen meeting. I think Evan and others have put together a really excellent program for tomorrow for the Next Gen meeting. It's good CLE. So I encourage everybody to either virtually or in person attend for the Next Gen program tomorrow. All right, so now I'm going to switch to our last program, substantive program of the day, Deconstruction of a Cross-Border Case. And I'm the moderator of that program. I'm a bankruptcy judge in the Southern District of New York. We get a lot of cross-border cases in the Southern District. So I said earlier that we sort of, some of these issues that are really increasingly coming up in cross-border cases really have come up in several of the panels we've already heard from during the program. And the hypothetical, I hope people have had an opportunity to review the hypothetical, because it's set up as a 3-jurisdiction problem, Brazil, the United States, and the UK. Arguably, the Caymans is also part of it, but we've tried to repeatedly simplify so we can get this done in an hour. I really feel fortunate we have an excellent panel, really experienced people from the US and elsewhere. Let me make some brief introductions, if I could. I'm going to do it in alphabetical order. So this is a hybrid program. We have 2 people who are on the screen, and I'll start with Susan Block-Lieb, who's the Cooper Family Chair of Urban Legal Studies at Fordham Law School, and very experienced with cross-border issues. She is also currently the ABI Scholar in Residence. I've attended other programs in which Susan has spoken. I really consider her an expert on EU insolvency law and other cross-border issues. So she's a delegate from the American Bar Association's Insolvency Working Group 5. She's got lots of other accolades and awards, and it's a pleasure to have her on the panel. Bill Brandt, who's immediately to my left, from Development Specialist, probably well known to everybody in this room, and who's appearing virtually as well. During the hypothetical, Bill is our CRO for our debtor. And one of the things we've tried to do with this hypothetical is build in lots of issues in each of the jurisdictions. And then how is Bill, as the CRO, going to find the solution to try and get to a consensual plan? So Bill is the founder and executive chairman of Development Specialists, Inc., better known worldwide as DSI. He's widely recognized, the firm is widely recognized as one of the foremost firms in corporate restructuring industry. So if you look at the program agenda, you can click and get the full bios of each of the speakers. So I encourage you to look at those as well. When we first started planning this program, we clearly wanted to use China fisheries as an important component of it. I think most of you have followed some of the history over a period of years, and Bill is centrally involved in that. And actually, the Singapore court just recognized and enforced the plan that Chapter 11 court, my colleague Judge Garrity, so some of this hypothetical is really built on issues that have arisen in in China fisheries. Eduardo Munhoz, who's on the screen, is a founding partner of Munhoz Advogados in Sao Paulo, Brazil. He has more than 25 years of experience as a lawyer, handling some of the largest restructuring cases, corporate transactions, and commercial and corporate disputes in Brazil. He's also a professor of law at the University of Sao Paulo and has published numerous works. Brazil, I think you've heard earlier, Daniel Costa spoke earlier about recent amendments to Brazil's insolvency law, adoption of the model law. They also have recently adopted the GIN guidelines, and we've certainly had a lot of cross-border cases with Brazil as a focus, RJ proceedings, main proceedings. To my right, Felicity Toube is a barrister with South Square in London, and she specializes in domestic and cross-border insolvency and restructuring, banking and financial services, commercial litigation, civil fraud, and company law. She also appears as a barrister in the Cayman Islands on a regular basis. She acts as an expert in international proceedings. You can read her full bio as well. We've heard from some of the other panels with Justice Zaccaroli and about recent changes in UK insolvency law, Part 26A, which we have built into this hypothetical. So it raises some very interesting issues with cross-class cram-down in the UK. They don't follow the absolute priority rule. That may or may not be an issue in recognition of UK proceedings in the United States in Chapter 15. So with that, let me turn first to Felicity to talk about, and if you've read, hopefully you've read the hypothetical, maybe you could just give a very bare bones view of it and go ahead and explain the issues from the standpoint of the UK. And one last thing I should say, Felicity was one of the barristers in the Gate Group case, which Justice Zaccaroli spoke about. She's actually been in a lot of the major cases that I've read and that have been talked about here. Felicity, please go ahead.
So you may see some echoes of Gate Group in this case. And also bearing in mind some of the conversation that we heard yesterday about the Swissport case. I'm going to say a few things about Swissport and also about Virgin Active. Now, I wasn't involved in Virgin Active, but I was involved in Swissport. And the reason why we're talking about English insolvency law here is you'll have seen in the hypo that GDM UK is a company which has been put together. It's a new English company, and it is acceded by way of a deed poll to the bonds. It hasn't become a party to the agreements, it's simply undertaken these. So the first question which the English court is going to consider in the context of what we've set up, which is a Part 26A restructuring plan, some people call it a scheme, it isn't, it's a plan. We've assumed we've got through the convening stage, we've had our meetings, and now we're at sanction stage. And we ask ourselves the question, will the English court sanction this restructuring plan? And the answer I give is yes. It will, of course it will. It's the most sensible way of proceeding. Now, of course, we know that the deed poll, which has been used, is artificial. It's being used expressly to take advantage of the English restructuring plan process. It is forum shopping. It's deliberately forum shopping, but it's good forum shopping. It's being used for the benefit of the creditors, including, of course, the US bondholders, who will benefit just like every other creditor. Because everybody will be doing better than they would be doing in the relevant alternative, which I'll come back to shortly. So restructuring plans, and I feel I should say this after some of the things we heard yesterday, are not all doom and gloom for creditors. They are actually a fabulous thing, and everybody should do them, and everyone should come to London. And if you want to talk to me more about that later, I'd be delighted. So we look at the deed poll and we say, well, it's artificial, but is artificial?
Why don't you just explain what a deed poll is? Because I think not everybody might be familiar with it.
So a deed poll is basically a one-way document that the company enters into, and it says, I accede to this document over here. You don't have to do anything. I will accede to your document. So I now have undertaken all the liabilities under this document, which you had bilaterally with someone else. but I will just accede to it. And let's assume for present purposes we're not worrying about questions of disclaimer, but a deed poll works. We know a deed poll works because Mr. Justice Zaccaroli said in Gate Group that it worked. And in fact, it had already been held to work.
So it's between which parties? The newly created GDM UK, which has just been created?
Yes.
To create this artificial jurisdiction in London?
Yes, it's good forum shopping. I feel like I should mention that again. So yes, it is entirely structured for the purpose of bringing this group's restructuring into England. Now, why is it doing that? It's doing that because of the Gibbs rule, and we'll come back to that in a moment. But these are English law governed bonds. So if you want to do something in relation to these English law governed bonds, you must do it in England unless you get everybody to agree. So, okay, the US bondholders are not very happy. Well, that's unfortunate. They have just invested in something with an English law governed bond. So once they've done that, the Gibbs rule comes into effect. It means that only an English process can do something in relation to it, and only an English law governed process can discharge the debt. So no matter what one thinks about Gibbs, and some people have expressed views that Gibbs is a bad thing, it is the law, it remains the law. It is the law at the Court of Appeal level in England. The Supreme Court is uninterested in changing it, having declined to hear the appeal. And therefore, this is the rule. You can only deal with these bonds in a process in England. So now you've decided you're going to do that, we go back to the question of the deed poll. Is there anything wrong with something being artificial in and of itself? Answer, no. What is wrong is doing things that are abusive. It is not abusive to bring your English law governed bonds into an English jurisdiction to do something for the benefit of the creditors as a whole and for the benefit of the company as a whole. And it's been used in the AI case, it was used in Selecta, it was used in Codera, and it was used in Gate Group. So we know that deed polls in and of themselves are not bad, they are not abusive, and this is dealt with at length in the Gate Group case, where there was an objection taken against the deed poll before the objecting bondholder pulled out, and the judge considers this at length. So what you need to do is you look at your deed poll and say, it's artificial, but does it actually do what it says it does? Is this company actually becoming a party to these documents? Yes. Does it intend to do something in relation to the documents? Yes, it's entering into a restructuring plan in relation to them. And so it doesn't matter that it's artificial. What matters is the proper characterization of it. So the combination of Gibbs and artificiality is not a problem. What then becomes the next question? The next question is the same question that came up in Gate Group, which is the question of third-party releases. Now, we've heard something about third-party releases, and it's almost seemed to be suggested that third-party releases are a bad thing. But why is it that we bring what's called Lehman necessity into the scheme jurisdiction and the restructuring plan jurisdiction? Well, the answer to that is the answer Mr. Justice Zaccaroli gave, which is you're looking for a ricochet claim. So imagine, for instance, I deal with all my creditors, and I can deal with them all very nicely in this jurisdiction. And those creditors then go off and claim under a guarantee against a third party. What does that third-party company now do? It brings its claim for contribution back to, in this case, the restructuring plan company. You have to deal with that because otherwise you're left with a ricochet claim. So you're not just randomly getting rid of third-party liabilities. You're dealing with third-party liabilities which are necessary to deal with in order to deal with your restructuring.
So here, the guarantee is by GDM Delaware, a Delaware affiliate of GDM Brazil, and now with GDM UK acceding to the liabilities, but the guarantee would be released. And while all the bondholders are of the same English law debt, the US bondholders oppose the plan and oppose the release of the guarantee. Is that right?
Yes, and no doubt they're very sad. But that doesn't mean that they win just because they have holdout value. It is far too simplistic to say that just because you have a US governed guarantee against a US entity, that means that the English court can't do what it has always been able to do. Now, we'll come back to recognition and effectiveness. That's a matter for the US court. But as a matter of English law, it doesn't matter what law governs that. I need to be sure as an English company that I don't end up with a contribution claim being made into me by Delaware. And the English court will have no problem with this. So no problem with deed poll, no problem with artificiality, no problem with good forum shopping, no problem with third-party releases.
So the plan that was proposed in the UK to pay bondholders 80%, they're taking a 20% haircut, unsecured creditors being paid in full, equity retaining its interests, the Delaware guarantee being released, the US holders of the bonds oppose. How are the classes set up for the plan in the UK? Are the UK holders and the US holders in the same class or a different class?
Well, one of the things that we've built into this hypothetical is that the UK bondholders are providing new money. The US bondholders weren't asked if they wanted to provide new money. They actually probably would quite like to provide it because it has a nice return. But as it happened, the money had to come in very quickly. They needed a bridge financing, much has happened in Swissport. And so, in fact, they only asked the UK bondholders and the UK bondholders.
So the UK bondholders were given a sweet deal for new money, and the US holders of the bonds have been cut out of it.
So the UK bondholders kindly provided the financing in order to enable this company to survive, Judge. I think that's exactly how you put it. So the English bondholders, the white knights on their horses, have come in, and the US bondholders would quite like to have joined, but sadly it didn't happen. So I think we need to put those in different classes. So we've now got the US bondholders in one class, the UK bondholders in another. They are both secured, so they'll be in their own classes, and then everybody else can come in together. We've got three classes, and shockingly, the UK bondholders and the unsecured have all voted entirely in favour, and the US bondholders have not, which came as a huge surprise to the company. So now we're into cross-class cram down, and we ask ourselves some questions. Now, we heard something of the test yesterday, although I should just clarify one point. It's not about whether they're better off, one of them is better off, it's about whether they're not no worse off. So in other words, it needs to be the same or better, and that can be relevant. You have to satisfy two conditions for cross-class cram down. The first one is to say that none of the members of the dissenting class would be any worse off. And the second is that it's been approved by somebody who has an economic interest. Okay, those are conditions A and conditions B. However, we've also been told by the English courts that they need to look at discretion. So it's not quite as simple as that. Now, I should say, none of this is terribly new or malign or a terrible direction in which the English courts have gone. And I say this because some of you may have got a flavor of this from one of yesterday's panels. In fact, this idea that you look at the relevant alternative is completely normal. This is exactly what we've been doing in schemes in England for years. We look at the comparator and we say, what is the comparator? And in this case, it's insolvency. What would happen if this deal were not done? The entire group would go under, and this new, lovely, lonely little company would die. So we have a relevant alternative, which is insolvency, and then we need to make sure that people are doing better. So we look and make sure that they're not being treated in an unfair way. They're not. Somebody got to put in new money outside the plan. Well, lucky them, they got a return. I do need to pause here just to say a couple of things briefly about Swissport and about Virgin Active. In the case of Virgin Active, Mr. Justice Snowden, as we heard yesterday, was dealing with a valuation dispute. it is not correct to say that there was no disclosure. There was disclosure in Virgin Active. It is not correct to say that there is no ability to get disclosure in the context of a restructuring plan. There is. In fact, there was another route which could have been exercised earlier. What happened in Virgin Active was that it appears that the valuation dispute came at a relatively late stage. The request for disclosure came at a relatively late stage. And the judge, and this is reading between the lines, seems to have thought that the landlords were attempting to disrupt the way in which that case was being dealt with by asking for more and more disclosure at the last minute, and he wasn't having it. And what he said was, I'm perfectly capable of listening to the valuation evidence that the companies put in, which was cross-examined for, I think, for 2 days, and determining the valuation dispute. So there certainly was a valuation, and it was tested. Again, it's true to say that there wasn't any market testing. Again, the judgment deals with this at length. Why not? Company was about to fall off a cliff. There was a burning bridge. It had no money. Doing market testing in that way is not actually the best valuation of a company, so it was done a different way. And then we go on to Swissport. Now, I should say, history is written, as they say, by the victors. And some of you listening yesterday may have got a flavour of the fact that those who were not the victors would like history to be somewhat different. Having been instructed by those who were the winners, I feel that it is important to mention that there were not bad actors. In fact, the question of what the US court was left open for the US, and as, again, you may have got a flavour of, that matter was not ultimately determined in the US. But you might ask yourself whether or not you should give all the power in relation to negotiating restructurings to people who are holdout creditors. So that's all I really say in relation to Swissport, which is it isn't quite as bad as you might think. In fact, it makes perfect sense and was an entirely successful restructuring which saved the company and a vast number of jobs. So for cross-class cram-down, we've got through all these questions of condition A and condition B. They're satisfied. There's no discretionary reason why you shouldn't do a cross-class cram-down. And I'm afraid to say that the US bondholders will find their class entirely crammed down because they will do better in this restructuring than they would do in the relevant alternative, which is liquidation. So that leaves us finally with substantial effect. I have to satisfy the judge at my sanction hearing that it is likely that this restructuring plan will be recognized in the US and Brazil. And luckily I have expert reports from very well-known people, some of whom may be in the room, saying that of course it will be recognized in the US and in Brazil. And the judge says that is all that he or she has to be satisfied of. And I'm really pleased to say that I have no problem at all getting my sanction order from the court, and I now have a sanctioned restructuring plan. So I think entirely straightforward, Judge.
So in the hypothetical, the disgruntled US holders of the bonds file an involuntary Chapter 11 in Delaware. The foreign representatives of the foreign debtor also seek recognition and enforcement of the Part 26A plan in Delaware. So Judge Sanchi or one of his colleagues now has for him or her the issue of the involuntary Chapter 11 case and the Chapter 15 recognition, seeking recognition. I'm assuming that your judge has made the determination that he believes it's likely that a plan, 26A plan, will be recognized and enforced in the US and in Brazil. And we're going to turn to Professor Susan Block-Lieb to tell us what are the impediments in the United States to getting that relief. And go ahead, Susan.
Well, thanks very much, Judge Glenn. I mean, obviously one of the impediments are the various standards for recognition of this Part 26A plan. And while I would admit that it is plausible for some forum shopping to be good forum shopping. And while generally in cases where there have been no dissent, that is near unanimous approval of either the scheme or the restructuring that's being proposed, good forum shopping would exist. Those creditors are clearly doing better as a result of the forum shopping. But the question I would have is whether it's possible for the test for a good forum shopping exercise to be a little stronger than that, right? Because no one is denying here that the creation of GDM UK was constructed not only at the middle of the night and behind closed doors, but also in the context of the US bondholders objecting to the plan previously proposed by the parent in this company. And so it seems to me that there are alternatives. Liquidation is not the only alternative. Where choices among options exist, it would be more appropriate to consider the various alternatives rather than the simplistic dyad that's being proposed by counsel for GDM in this context. And I may know a little bit about EU law. It's not relevant in this hypothetical any longer. I know even less about English law. What I know about English law is mostly limited to schemes of arrangement and these new Part 26 restructuring plans. But one thing I do understand is are some of the facts that have been conveniently omitted from the recitation of the case thus far. And so the US bondholders are not simply holdouts taking their 1 or 2 or 5% position and trying to make that tiny little final hair of the tail wag the dog of this restructuring. The US bondholders hold 30% of the outstanding debt amount. And that means, my understanding is that means under English law, in the absence of separate classification of the two groups of bondholders, the Part 26A plan or any other sort of plan would not be subject to sanctioning or confirmation, if you will, by the English court. Moreover, there's no cliff here. It was a purely technical default by the company which produced a restructuring, an RSA, a restructuring agreement that prompted a sort of comfortable payment default, but there was no cliff here whatsoever. So I would question, first of all, whether liquidation is the relevant alternative. Chapter 11, the involuntary petition, there's absolutely good grounds for the filing of the involuntary petition in Chapter 11. There's no question but that the Delaware Bankruptcy Court has jurisdiction over GDM Delaware's, the petition against GDM Delaware, and under the federal venue provisions under its affiliated corporations in this group. There's obviously not just tiny assets located in bank accounts in Delaware or elsewise. There is an entire processing plant located within the jurisdiction of the United States. Now, GDM could seek a dismissal of this case, presumably on a demonstration that it's generally paying its debts as they come due, but factually that's going to be quite difficult. And my understanding is they actually kind of want Chapter 11 for reasons that the CRO is going to explain subsequently. The problem with confirmation of a Chapter 11 plan, that's not why they want Chapter 11. They can't confirm a plan because cross-class cram down violates what would otherwise be understood to be the confirmation standards in Chapter 11. But let's move away from Chapter 11 and talk about Chapter 15, because we have these letters from academics. How much did you pay for them? Where are they? Why are they so certain that the restructuring plan under 26A should be recognized under US Chapter 15. The standard for recognition is a satisfaction by the Bankruptcy Court that GDM UK has its COMI in the United Kingdom. This single purpose vehicle created in a dark closet in the middle of the night in order to obviate the interests of the 30% of the US bond, 30% financial interests of these US bondholders. And while US courts have recognized schemes of arrangements, and even more recently, a restructuring plan under Part 26A, there was the Deep Ocean case relatively recently. There are holdings where courts have laid out the possibility for declining to recognize a Part 26A restructuring plan of this sort, which involves, I would argue, forum shopping that isn't all that great. And here I'm talking in particular about the holding in Cordair Finance 2. Now, in that case, similarly, a single purpose vehicle was created to vest an English company of some sort with responsibility under a bond offering, and it filed then under, I think it was a scheme of arrangement rather than a Part 26A. The court ultimately recognized the proposed scheme in Cordair Finance 2 UK, but it did so only after interrogating, if you will, the director of that single purpose vehicle to establish the good faith of the company's just-in-time creation of a single purpose vehicle. And the director was quizzed about exactly what his responsibilities were and other indicia of presence in London or elsewhere in England. And the court was, to a degree, concerned about the just-in-time creation of the single-purpose vehicle. The facts in Cordair 2 are quite different. I would differentiate between that case and this one, because there it was 100% of the creditors voted in favor of the proposed scheme of arrangement. And there was no need for separate classification, none of those other, no smoke and mirrors, no tricks. It was all very straightforward. And so here I would argue that what's been going on is really quite different. And I would point to the decision in Ocean Rig, which really is the US test for COMI recognition in the context of best applicable in this sort of a context. And Ocean Rig looks for whether or not there's been insider exploitation, probably not here, untoward manipulation. I'm going to say, I'm going to try and hang my hat there, but more importantly, an overt thwarting of third-party expectations. And I think that's precisely what we have in this case, is an overt thwarting of third-party expectations. We've got the release of the guarantee by GDM Delaware, as well as the separate classification in order to manufacture a sanctioning of the Part 26A restructuring plan under the cross-class clampdown that's available there in England and not in the United States. Short time period, yes. So I guess one other quick rejoinder, and that is as relates to the Gibbs rule. I don't think that the Gibbs rule should be relied upon by counsel by English counsel in appearing before the Delaware Bankruptcy Court seeking recognition of the Part 26A restructuring plan. The Gibbs rule, in other words, should not be used as a blank check for recognizing whatever it is that the London High Court sanctions. There's room for negotiation here, and there's been no effort at negotiation, nothing other than bullying. That is precisely what we argue constitutes overt thwarting of third-party expectations. Thank you very much, sir.
All right, Eduardo, so you've had recent amendments to your insolvency law. You recently adopted the model law. What will you argue in your courts, or what will the arguments be as to recognition in Brazil? Obviously, GDM Brazil, it's the principal company, its COMI was in Brazil. There's no doubt about it. They created this new UK affiliate with arguable that it has COMI in the UK. What are your courts going to do?
Yeah, as well. Thanks, Judge Glenn. Well, first of all, I have to say that we'll be in really unexplored path or territory in Brazil with respect to this case. Until last year, before the enactment of the new law that introduced the cross-border insolvency chapter in the Brazilian law, my response would be very simple. I would just say it would be impossible to recognize and to enforce this UK plan here in Brazil. We just didn't have this concept in Brazil. But obviously now, since the law was enacted, and the Brazilian law is pretty much, let's say, almost the translation of the UNCITRAL model to the Brazilian law, I believe that we would have grounds to discuss this case, and that's what I will try to do here, except take into consideration the fact that obviously we don't have a number of precedents, and we would be really building a new path here with respect to this cross-border insolvency case. First of all, with respect to the recognition and the enforcement of the UK plan in Brazil, the first challenge would be exactly the one that you just pointed out, which is the fact that it's clear that the COMI of GDM Brazil is in Brazil. So to a certain extent, we could say, well, it would be impossible to recognize the UK proceeding as the main proceeding, since the Brazilian law, following the UNCITRAL laws model, says that one of the requisites to recognize a foreign proceeding as a main proceeding is exactly the fact that the COMI is in the country where this proceeding is going on. So the first point would be in Brazil to say, look, we cannot recognize the UK proceeding as a main proceeding in Brazil, since there is no COMI in UK. And we don't have, as we just heard with respect to even the UK law or even the US law, we haven't developed yet concept like, for example, well, this is foreign shopping, yes, but it is in good faith and it's not harming Brazilian creditors. We don't have this concept clearly contemplated in the Brazilian law, but I believe that we would have grounds to try to defend, and that would be a way to defend the possibility of this recognition that actually the main proceeding was filed in UK by a foreign company, a company organized in UK. Even GDM Brazil itself is not a company organized in Brazil, right? It's a company organized in Cayman Islands. So that would be another point to say, look, we are not dealing with a really Brazilian company. So we have to analyze this COMI concept take into consideration that we are dealing with companies that are not organized in Brazil. And more than that, even the creditors are foreign creditors, and the law who governs those bonds are English law and US law and not the Brazilian law. So that could be a way to try to defend that, regardless the fact that the company of this group is in Brazil, the Brazilian courts should recognize this proceeding as a foreign proceeding that could be recognized and be enforced in Brazil. But Judge Glenn, something that we have to take into consideration as well, as it is described in the hypothetical, is the fact that also the GGM Brazil would be filing a Chapter 11 in Brazil, right? So GGM Brazil would be filing a Chapter 11, and we would have some challenge with respect to that as well. The first one is the fact that GGM Brazil is not organized in Brazil, but it's the parent company of a group, and there are Brazilian companies organized in Brazil. Even one of them, it's a company, which is a public entity, a Sociedade Anônima Aberta in Brazil, organized in Brazil. And we have some precedents in Brazil accepting Chapter 11s in Brazil when you have Brazilian companies organized under Brazilian law, and also some other entities organized in other countries, if you are able to demonstrate that those foreign entities are vehicles or parts of the groups, and that the main activities are rendered in Brazil. And the Brazilian law allows the concurrence of a Chapter 11 and also the foreign proceedings. So with respect to the assets that are in Brazil, those would be handled in the Chapter 11 proceeding. And that could be another way to try to convince the same judge, because in accordance with the Brazilian law, the same judge would decide not only the Chapter 11 case, the recuperação judicial, but also the proceeding in order to recognize the foreign proceeding in Brazil. So this court would have, let's say, a broad view about the situation. So that could be a way for the Brazilian court to deal with this case, in the sense that, well, I will handle, let's say, the situations related to the Brazilian assets and the Brazilian creditors in the Chapter 11, the Brazilian proceeding, main proceeding, and I will recognize the foreign proceeding that is dealing with the foreign creditors and also the assets that are not in Brazil, in a way that there is no conflict between them, and the hypothetical that doesn't imply that it will be any conflict, and even that there will be any harm with respect to the Brazilian creditors. So probably that would be the way the Brazilian courts would analyze. Those are the legal grounds to analyze the situation and this case. But there is no doubt that since the new law is pretty new, pretty recent, we could expect to have some resistance from the Brazilian courts in terms of recognizing and giving enforcement to main proceedings that are based on, let's say, forum shopping, or where you can see that the center of decisions and the nerve of the decisions and the main activities are rendered in Brazil. I don't think it would not be feasible. So I can believe that an expert rendered the legal opinion that Felicity presented to the UK judge. But again, it would be something really, it would be a huge challenge, this case here in Brazil.
Okay, so Bill, you've been appointed as the CRO for GDM Delaware, but really your real role is to see whether you can get some order out of chaos. So listening to Felicity, Susan, and Eduardo, it seems to me that there are a number of serious issues without clear resolution. First, is the Comey of GDM UK going to be recognized by either a Brazilian court or a US court in the face of opposition by a large group, 30% of the bondholders? And if the Comey is not recognized to be in the UK, can a Chapter 15 plan be recognized? Can the foreign proceeding be recognized in the US in a Chapter 15 case? The plan, as proposed, the 20% haircut for the bondholders, unsecured creditors recovering in full, equity retaining their interests, couldn't be confirmed over the vote in a negative vote of a class of creditors if the two classes of bondholders or that's the classification in the US because of the absolute priority rule. In that context, should a Part 26A plan be enforced if a plan such as that could not be proposed and approved in Chapter 11? Then you have the problem that a US court, because of the Gibbs rule, if it did modify the English law debt, it probably wouldn't be enforced in the UK over the objections of UK bondholders. So we're perhaps at loggerheads. How do you, as the CRO, try to bring some order out of this chaos?
Well, thank you, Judge. I think one of the models of my firm comes into play first and foremost, and that is, if you don't drive events, events will drive you. And as Dan Glossman said to me last night, this is a hypothetical. I recently lived for about 4.5 years, so I have some ground to speak on it. Indeed, Judge Gropper and I and Charlie Booth have remarked on this over the years as we've taught the St. John's seminar. A couple of things. First of all, I'm taking what Chuck Case said last night. The first thing you are not is a cultural imperialist. I learned that. I recognize that each and every one of these sovereign nations has enacted laws which they think are designed to help them through insolvency and, in some cases, attract new venue cases. It's as Judge Sanchi said, there is a certain marketing effort going on worldwide, and we're all better for it. But on the other hand, I look at the question at the end of the hypothetical, Judge, you posed, which was, how does the GDM group continue to trade through? One of the things I've learned about Part 26A, which, by the way, I think is a marvelous development in English law, and will, as Judge Sanchi said, have Felicity very busy in the future. The problem is that the confirmation of the Part 26A is essentially necessary to be finished before you can give any loaned money to the corporation. You have no guarantee, in other words, of doing it. Effectively, the fastest way to get money to a debtor at this point is still the traditional old American DIP loan, which you can do as part of the first day order. You can't do that with a Part 26A. I tried in the Fish case, but they're not there yet, I think it's safe to say. So what would I do? Well, as all of you know, and I've been prone to break some glass in the future and in the past, I would take my CRO role very seriously. I would, if you look at the hypothetical, there was an involuntary filed by the seamen and the American bondholders. As the CRO, I would immediately move to convert that to a voluntary 11. I would not do that to try and diss, if you will, either the English proceedings or the Brazilian proceedings, but I would do that on the basis that the company needs money now to operate, having run a fishing company. And the fastest way I can get money in is a DIP loan on a first or second or third day order. And to do that, I would gather the bondholders, who I take it like typical bondholders, and I've now received a lot of holiday cards from those kind of folks, which often simply say drop dead. But I get those cards all the time. I would gather them in a room and I would say, look, 80% of a haircut seems to be too good at this point, and we need money. Here's a suggestion. I need money from all of you. I would like to suggest that I'm going to propose a plan that gives you a 70% haircut. And in proportion to that and your holdings in the bonds, you will give me 35 million from the English bondholders and 15 million from the American bondholders at a far more reasonable coupon rate than 20% and 3.5 fee, which Felicity, if you can get, God love you. I will admit that inflationary times are back, and so maybe we aren't doing 4 and 5% coupons, we're back to 10, but I'd go with that. And then I talk about, in connection with getting the DIP loan in place very quickly, a longer-term plan where maybe the bondholders take a 70% haircut. The guarantee in Delaware remains in place for that 70%, at least the remaining bonds. And in addition, the bondholders, both the UK and American bondholders, get warrants for perhaps as much as 35 to 40% of the reorganized company's equity. That's how I would initially propose the plan. I also would think that, as I've done in China fishery and in other cases, I'm not doing this for the sheer dominance of the American court system. I don't believe that to be the case. I believe that what we've done here is craft a deal around the immediate need for money, which gives you the rationale for the deal. I believe in the Gibbs rule. Judge Glenn and I could have a long debate about this. I've seen his opinions, but as Felicity says, it's still out there and they're still enforcing it, so you have to pay some attention. So what I would do in the plan, if I could confirm a plan this way, which would be pay the creditors in full, cut the bondholders by 30% instead of 20%, more reasonable coupon, and then give the bondholders a warrant, would be then, as a condition of confirmation, go back and seek, first of all, approval of the scheme or approval of this plan under the scheme in the UK to bind everybody under the Gibbs rule. Secondarily, I would also then seek to go back to Brazil, because Eduardo was right, that is Comey, although generally Comey schmomy. You know, venue shopping is a wonderful thing. We should all engage in it more often, I believe. But nonetheless, I would go back to Brazil because he's right. And I would ask the court to have a blessing from the Brazilian proceeding on the now confirmed US plan and the English scheme plan, so that all three courts bound their respective creditors in their respective nations and worldwide to the plan. There are a couple of things I've learned in China fishery, which are rules for living. One is that you never want to ask an American judge, or for that matter, a British judge, no matter what they think of themselves, for an extraterritorial order, which on its face may not be enforceable. That diminishes the court's standing in my mind, and also diminishes your ability to bargain in other locales. So only ask for orders you think on their face are enforceable, and by that general doing are mostly consensual. The second issue is you can make no one nation's court the appellate court for the last nation. In other words, as I used to say in Peru when I was in Peruvian courts, if I didn't like the outcome in Peru, I couldn't make Judge Garrity in New York effectively the appellate court for Peru. That, as Chuck Case would say would be cultural imperialism. So you've got to work through these issues consensually. You've got to make sure that you present each of the courts with the proper deference, but you list out a way to do this which provides some fashion. Now, for those of you that know me, many of you will take a brief breath and say, you just convert that to an 11? Yes, immediately. It will get people talking. Once I do, I'll gather either by Zoom or in a room, and I'll say, look, the deal in England is too rich. You guys know it, and ladies know it. I can get you faster financing than I can get under Part 26A. I can get it now. It requires a little concession on your part, a bit more inclusion, and then we go up the tree again in a reverse process. Confirm in the US, leave the guarantee in place, which will help the bondholders, go to the Part 26A, and then go back and use Eduardo's capable services to make sure that a judge in Brazil has blessed this, since in fact this is a Brazilian company. So Judge, in a quick response, that's how I do it. I'm sure that will throw people up for grabs, but It's how I think you need to try to run the line to get these things done when you have several nations' courts, each thinking they're in charge.
So Felicity, let me ask you this. Assuming that Bill persuades the bondholders, UK and US, to modify the deal and gets the unsecured creditors to take a deal that modifies what their rights might otherwise have been, what do you have to do in the UK? Do you have to start a new 26A proceeding? Can you modify the existing recognition? What do you, as a practical matter, have to do in the UK?
So we'll have to start a new one, but this one might be a bit easier because we have a plan that everybody's actually agreed to, which is always a good start. I will be quite sad because Britain quite likes an empire. I may also feel that
Do you get a separate fee for this separate 26A that you now have to?
You know, I do. I do. I feel that it's important that we should do things twice if we can. Codera has done it at least twice already. And I also feel that I would have had a good chance under the Chapter 15 because I know that Judge Gropper, who is always correct, has said that this is the US is much better than England in terms of its model law. But nevertheless, reluctantly, I would take my fee and do this again.
Eduardo, do you have any further comments? I'm going to come back to Susan and Bill in a moment, and then I'll open it up to questions.
Sure, no, just, well, I received the chat here. Someone said, look, in Brazil, it would be very difficult to get the recognition since we have the Article 167J of the Brazilian law that deals with exactly the manipulation of the company. So that's exactly the challenge that I tried to point out. The question here is, which I believe makes the case interesting, and maybe we would be able to try to defend the recognition here in Brazil, is the fact that GDM Brazil actually is not a company organized in Brazil. So by itself, it's a foreign company, and that would maybe make this case more a foreign case than a Brazilian case. And we're also the fact that the plan will deal with foreign creditors, and that the creditors are, the majority of them are accepting the plan. So maybe the same kind of reasoning that we could try to get the recognition by means of the Chapter 15 in the US could be, let's say, tried in Brazil. I don't see why those kinds of principles could not be accepted in theory by the Brazilian law. It would be something very, very different if the GM Brazil were a company organized in Brazil, with its, let's say, it's under the Brazilian laws, as is the case in the hypothetical of the A and M company. In this case, I think the recognition could be very not probable. But I think that the fact that GM Brazil is a foreign company, that could create grounds to try to get the recognition.
Susan, are you happy now that all of the bondholders are on board with this modified proposal? And can you get both a Chapter 11 plan confirmed and a Chapter 15 recognition approved?
So I think that the confirmation of the Chapter 11 and the recognition of the Part 26A that I understand is being negotiated is much more likely to get recognized. So I'm moving toward this being an exercise of good forum shopping, which has involved give and take in this context rather than cross-class cram down.
I can just say for myself, I'm always much happier when the parties have reached an agreement and I'm willing to go along with it. Bill, you managed to pull the rabbit out of the hat in an hour presentation rather than 3 or 4 years. So.
The only thing I would add is the hypothetical had a great platform, as Eduardo saw as well. The Brazilian subsidiary trades publicly in Brazil. Never forego a great platform for a consensual outcome. With a publicly traded event, those warrants could be in the money as soon as you finish confirming this plan. The second issue is don't get tied up into Chapter 15. I think at some point, if you've got a working Chapter 11, just ask for the Chapter 15 recognition to be withdrawn and let it go by the wayside. What I'm seeing in the US is more and more companies are filing Chapter 11 here. Chapter 15 is interesting, but it's an ancillary proceeding. If you've got a case going on, it's really ministerially what you do with it. It shouldn't drive the case.
Are there any questions from the audience or on chat? Mark?
Thanks, Judge, and thanks, everybody. I thought this was a great panel and a meticulously crafted hypothetical, but at the risk of disturbing the hypothetical, suppose that instead of holding a minority position in English law governed bonds, the New York holders held a separate issue of New York law governed bonds. I'd like to find out from Felicity and Susan if this clever little device of the deed poll would have worked to assume the liabilities under the New York law governed bonds. If not, might the issuer of those bonds have converted them or amended them so as to change the governing law from New York to UK? And then if you've manipulated that much, have you finally crossed a line between being merely artificial and abusive? And then after that advice, I want to find out if Bill would do anything different.
So as we've got minus whatever it is minutes, my first temptation is to change the governing law of the US law governed bonds back to English law, and I'm back into my hypothetical, so that would solve the problem. But if I can't do that for some reason and I'm left with US law, then I have a more difficult time, much more difficult time. So I won't for a moment admit that it's abusive, because there are other routes to getting a plan or a scheme through in the UK, but that does, Gibbs is my savior, and that's the reason why we wrote it into the hypo, because that's your tag. And that was the tag that there was in Gate Group as well.
Susan?
So the abusive test may be the test that English courts apply, but in the United States, it's a question of, among other things, overt thwarting of the third party expectations. So yes, I do think that we still have that, but otherwise I was pretty happy with Bill's proposal. So changing it doesn't make me super happy.
I would just say that I have recognized and enforced English schemes of arrangement that have modified New York law debt. Unlike the English courts, we will permit courts in other countries to modify New York law debt, assuming that they have jurisdiction over the case. Obviously, the English
This is that beer I was talking about. We could have and discuss this forever. But the fact of the matter is, I'm a big believer in English schemes. They work very, very well. The Part 26A development is a wonderful new development. In the case of China Fisheries, we took New York bonds after confirmation and put them under English law, specifically to take advantage of the scheme. So I'm all good with the scheme. The problem I have is, and it's still a problem for the UK and in Hong Kong as well, there is no DIP financing. You can't get financing secured in a Part 26A scheme until it's finished and confirmed. The business can't wait that long. The redeeming virtue of the American venue is first day orders, I can get a DIP order, and we all know how to do it, and a business won't wait.
The last comment I'd make is, and I see in the audience there are members of the National Bankruptcy Conference, and it previously proposed a new chapter in Title 11 that essentially would create a scheme of arrangement system in the United States. And I think you ought to renew that effort. I think it's a very valuable tool in the toolbox. And I think it's not just a question of competing against those jurisdictions that have it. It would be a very valuable tool in the United States. The National Bankruptcy Conference proposed it before. I don't know whether there's any activity to try again, but I think it would be a very good addition to the Bankruptcy Code. With that, let me thank my panelists. And again, 15-minute break, 13 minutes, we've run over a little bit. And then everybody come back in if you would, so we make sure we have a quorum for the members' meeting. Thank you very much. Thank you.